Sue Moroney.
Thank you, Mr Chair, and I thank members for their contributions on the debate on new Clause 6 that we've had so far. I just wanted to put a little bit of context around why we've got Clause 6 coming forward in the shape of a supplementary order paper, in fact 2 supplementary order papers, which makes it quite difficult to debate, so that members could understand that, because it forms part of the history of this debate and what we've done with this bill. But before I do that, can I just take the opportunity to acknowledge that I've had the first acknowledgement from the government benches for bringing this issue forward, and gosh, it's taken almost 3 years to get that, but today finally a government member actually said that this was a good debate for our country to be having, and that's certainly a slight change in attitude from the government benches, so I think that's worthwhile acknowledging. Mr Chair, we are debating these new clauses, well, this new clause I should say, because this is the debate on Clause 6, as 2 separate supplementary order papers for this reason. We had very good advice from officials at Select Committee. In fact, the Select Committee process on this bill was very robust, and we had official advice from a range of ministries, and it was really a very good example of having a whole of government response to an initiative, because we had officials from the Ministry of Education, we had the Ministry of Health, we had MOBI, we had Treasury, we had IRD, all in the room and advising us for the Select Committee process. And so they were able to take my humble members bill, which I think initially had just 5 clauses in it. I thought I could get away with a 2-sided piece of paper that would deliver 26 weeks paid parental leave, and found as a private member it wasn't quite that simple, almost, but not quite that simple. And so new Clause 6 was something that was discussed substantially at Select Committee, because the officials advised us that in drafting this bill, what would be best would be to describe each of the 3 phases coming in of this bill, because I had designed it so that all the 26 weeks wouldn't come in all in one financial year, that it would be staggered over the course of 3 years. And the advice from the officials was that that was best done by separate clauses, rather than actually lumping it all together in one clause as I had done. And so, in the normal path of things, the Select Committee would have agreed that's a very sensible thing to do. We would have reported back the bill, and it would have already had Clause 6 in it, or as an amendment from the Select Committee. That could not happen because of the politics that was being played in the Select Committee at that time. What in fact happened was the National Party asked me for an extension of time to report the bill back to the House, because they wanted to consider accepting my proposal. And I agreed, because while I sniffed the scent of a political game, I didn't want to do anything that would disadvantage New Zealand families from having this opportunity to actually get 26 weeks paid parental leave. So I took them at their word. Because they said to me that if they made any changes to paid parental leave, any improvements to paid parental leave, it would be done in my bill, in my name, because it was already in front of Parliament. What transpired is that they spent the next 2 months twiddling their thumbs, playing for time, using delaying tactics, not considering that option at all, and then voted the bill down at Select Committee.
Order. Now, I think this is now either the 3rd or the 4th time that I've issued a warning to the House in committee about the fact that this is a very narrow debate, and a historical going over of what happened at the Select Committee, not on these clauses, cannot possibly be in order. So can I ask that the member in charge of the bill come back to the very, very narrow debate that we're going to have if it is to continue?
Sure, thank you, Mr Chair, for the advice and the guidance. I probably did get a little distracted because I was talking about the reasons why Clause 6 is actually in a supplementary order paper, and it was because we couldn't conclude as a select committee what we had previously agreed on would be some sensible amendments to the bill. We couldn't agree that as a select committee, so I have, as a member, had to bring them forward as a supplementary order paper, and one of those was in fact Clause 6. Clause 6, of course, had to be amended again by another supplementary order paper once I had determined as a member that I wanted to try and reach a compromise. And that compromise has been traversed in the course of this debate. Members have asked me what the cost differentiation is of that compromise that is embodied in Clause 6, and effectively it brings the cost of this bill down from being $50 million in the first financial year to being just $6 million in the first financial year.
Jamie Lee Ross.
I move that the question be now put.
Catherine